Today, I am trying make an endeavor to explain to you the transfers which are absolute. So, where absolutely all the interests and rights in a property are transferred into hands of a transferee, are certain types of transfers like sale, exchange, gift, and actionable claim. I'll do my best to explain to you all in as lucid and simple language as is possible to me. Now, as please motto is that every advocate should ultimately share and impart his knowledge and transfer it to its the new entrants in the legal profession. Whatever experiences over the last 29 years which I have garnered, I would try my best to share and discuss and explain to you how I, as a solicitor, have evolved and started understanding what the transfer of property is. Ultimately, like last time, what I said, that everything is logical common sense. And today, again, my endeavor would be to do so. Like last time on 4th, I discussed till section 53A, that is till part performance. Today, I will go into the absolute transfers. And sale is one of the modes where the property, the entire interest in a property gets transferred absolutely. And if you see the sections 54 to 57 is what deals with the chapter of sale. What is the definition of sale? What are the rights and liabilities of a seller? What are the rights and liabilities of a buyer? One just looks at the provisions and would realize that even a normal man who would want to sell his property would be thinking in those lines regarding his rights and his liabilities. Only the legislature has documented a mindset of a human being into law book. That's how simple it is. So if you see what is a sale, right? A sale is transfer of its ownership in a property in exchange for a price. Now that can be partly paid and partly promised, but ultimately for the sale to go through, absolutely, the entire amount has to be paid. Now, sale has to be where there is an absolute transfer. There is also a concept where it is a contract for sale. Now, contract for sale doesn't create any interest in the property, and that aspect has been dealt with by the Honorable Supreme Court by three-judge bench. It has laid down, which I will explain subsequently. But sale, the effective part is that the entire ownership is transferred to the person to whom the property is sold in exchange for a price. And for the sale to be effective or to take place, it has to be, if it is more than 100 rupees or it's a intangible thing or a reversion, it has to be under a registered instrument. Now question arises that why a registered instrument? Sell, because ultimately it is a right in rem where the property gets transferred. The person who purchases the property gets it against the entire world. It is a right in rem as opposed to a right in persona. Now, I take it that many of you would be aware what is a right in rem and a right in persona. Right in persona is only a right which is against one other individual or a class. But a right in rem is as against the world. Now it requires this document to be registered because the entire world should know, if they take all precautions which is required in law, like taking search with the sub registrar, they would know to whom does a property belong, because ultimately the entire concept of transfer of property is to protect persons acting in good faith. Persons acting in good faith means somebody who does not have notice or with proper care would not be aware of certain fact. Once sale has taken place through a registered instrument, person who would want to subsequently purchase, or if the seller wants to subsequently sell it to somebody else, would not be in a position to sell it, because if the other party is prudent enough, he would find out that already a sale has taken place. And therefore, law requires that if a sale has to be effective, it has to be by a registered instrument. Again, therefore, extremely logical, putting notice and making people aware to avoid frauds and misrepresentation or cheating taking place. So this is how the concept of sale is. It has to be effected by a registered instrument where value is more than 100. Otherwise, it can be by oral document also, oral understanding, as well as only by delivery of property. Now the question arises is, when the sale is to take place, sometimes before the entire sale taking place, parties would want to understand relating to the title of the property, or whether there are any requisitions or any acquisition notices, or whether there is any encumbrances on the property. So there is a concept for contract for sale. Now, contract for sale is not sale. And as I pointed out to you in this judgment of Raheja Universal versus NRC, where I was one of the persons, solicitors who was in the matter. We fought, it's a reported judgment of Bombay High Court, where our firm had appeared for NRC Limited, and we were advising NRC Limited then in Supreme Court also. It is reported and it is stated in this judgment that it is manifest that a mere contract for sale of immovable property does not create any interest in the immobile property. So a contract for sale per se doesn't create any interest in the property. The right is only as a charge relating to the purchase price paid in the rights of the seller in the property. That's what section 55 would explain. So it per se doesn't create, it creates only a right under specific relief act for seeking specific performance of the contract. That is to get a conveyance or a sale deed in accordance with the contract for sale. So if parties enter into a contract for sale of immovable property, the sale has to take place in future on the terms as settled between the parties in the contract for sale. And as I pointed out, it does not by itself create any interest in or charge on such property, because that this is not a executory contract, executed contract. It is a to be executed contract. So therefore, to make you understand the difference between what a sale and what is a contract for sale, what is the major difference, I tried to make a chart and explain to you. As I said, sale is transfer of ownership. In a contract for sale, there is no contract of ownership taking place. Sale creates a right in rem, whereas contract for sale is a right in personam. In a sale, section 54 makes it compulsory that such a document has to be registered under the Indian Registration Act, section 17, which is the provision for compulsory registration of documents. Sale is one of the documents which is compulsorily registrable, whereas contract for sale need not be registered at all. Sale is an executed contract, that the contract is in execution, it's in coming to force, whereas this is executory contract. It's certain things are to be required for the ultimate transfer to come into force. So this difference is very important. Sometimes if you would have seen it, uh, technically people just have an agreement for sale, and then they say that we have a right in the property. That has created several problems, even relating to a flat. People enter into an agreement for sale, and then they say it is a we are the owners. No, even if there is an agreement for sale and there is a part payment provided, you ultimately have to enter into a sale deed. In an agreement for sale, if you are paid the entire stamp duty, then in the sale deed that would be adjusted and you have to pay the minimum stamp duty. So this is very important. Many a times contracts which a party, if transactions have failed because the solicitors have advised that the transfer has not become absolute. And then it becomes difficult because the transferor, the original transferor, either is not traceable or it's very difficult to convince him to enter into a sale deed, or he is now not in the world. So therefore, the difference between a sale and contract for sale has to be very, very carefully understood by every person whose intention is to ultimately practice law and to practice the conveyancing side of law. Now, as I said, the rights and liabilities of buyer and seller. This is when parties enter into a contract for sale, and the sale has to take place over a period of time on a future date. Then, before the completion of the sale, the seller continues to have the right to the rents and profits that arises from the property. Now, definitely this is logical. People, unless there is a contract to the contrary. Now, most of the provisions, many of the provisions are always contract to the contrary. It's not hard and fast rule. If there is nothing mentioned in the contract, then such a provision will apply. But if the parties say, sorry, the buyer says, even if before completion of sale, I should be getting the benefit of the rents and profits, and the seller agrees, and that is mentioned in the contract for sale, then what is mentioned in the contract will prevail, not the statutory provision. The statutory provision is subject to the contract to the contrary. So again, legislature has been very conscious of the fact that this is a contract between two adults, between two parties who are competent to contract. So we leave it to their wisdom, what they want to do. We do not want to enforce any our thought process or what we think on the parties. We leave it to them. But if there is no such contract, then logically, since the sale has still not taken place, it's to take place in future. So till the ownership passes to the buyer, whatever the rents and profits which are arising from the property has to be to the benefit of the seller. Again, this is very logical, because person, suppose the property is sold subject to a tenant. There is a tenant occupying. And if the law would have provided that rent has to be paid to the buyer moment there is a contract for sale, for some reason, if the contract for sale fails, or there is a breach, or is not enforced, then again the tenant is again confused. He will say whether I pay to the buyer, I pay to the seller. So it's been kept very logical. Before completion of sale, pay to the seller. After the sale takes place, after you are informed, pay to the buyer. That's how simple and logical the legislature has been thinking about. And after sale, what is the seller entitled to? He is, if there is in the conveyance deed, if there is a provision that certain part pay subsequently, then the seller is entitled to a charge on the unpaid purchase money. So whatever is remain to be paid, if there is to be paid in installments, what remains, he has to be paid only purchase money. The Honorable Supreme Court in a recent judgment and has held that if there is a default in payment of the purchase money when a conveyance takes place, then a seller cannot terminate the conveyance for breach. He is only entitled to a decree for receipt of the balance purchase money with interest, if at all, if it is mentioned or not. If not mentioned in the contract, then after notice under the interest act, he would be entitled to the interest which is statutorily provided. So that again is a very important aspect, that once you do a conveyance, the seller has to be advised that if there is a default in payment of the balance purchase money, he would be entitled only to decree for recovery of the purchase money. There cannot be any termination of the conveyance. Again, unless there is a understanding between the parties to the contrary. Okay. So again, the legislature has been very, very particular and logical, saying that once a sale has taken place, once it is a right in rem created, once it is registered to the knowledge of the world, you cannot have go back and forth. You just have to move forward, right? Now there are certain liabilities on a seller, and certain liabilities or certain duties or obligations of seller and buyer, where it goes to the root of the title. If that is not brought to the notice of the buyer, if he would otherwise not be aware, then it is considered to be fraudulent. The act provides, it's very stringent, it is fraudulent. And one thing I would want to tell you, that fraud vitiates everything, and fraud goes to root of the matter. So if something is based on a fraud, then everything in furtherance thereof or subsequently gets vitiated and is void. So therefore, the legislature has put in a very stringent duty on the seller, saying that if a property has to be sold, if there is any material defect in the property which the seller is aware, and which the buyer, even if he takes every care to discover, he would not be in a position to discover that, then seller has to bring it to the notice of the buyer. That's a fundamental duty. And if ultimately that material defect is found out and it affects the right of the buyer to enjoy the property, it will go to the root of the matter and the entire transaction fails as being fraud. And other, again, very logical, he has to produce all documents of title for examination by the buyer. Again, this is very important, because if for some reason the documents of title are not with the seller, then it can lead to many other possibilities, like whether the documents of title have been given for as a security for securing some loan, or whether there is a some person has a charge over the property, or whether the property has already been sold. So all those aspects are there. So therefore it is very necessary that all documents of title have to be produced for examination of buyer before a sale takes place. Then the buyer, after inquiry, may have some questions, some requisitions relating to some, maybe there is a transmission taken place, or if they were joint owners or co-owners, one of them have passed away. So relating to all those requisition questions, all this the seller has to answer. So buyer has to have a right to ask all the questions which is relevant before he completes the sale. And then thereafter, definitely when the entire money is paid, then to execute a proper conveyance. And again, very very logical, that if you have sold the property and still if you have not given the delivery, then you have to take care of your property as you would always take it as a owner, and you will take care of your documents of title also, and you will not put the property into any jeopardy by not paying any public charges, any tax which allows the property to be auctioned or attached. So all those, if you see all these 6 duties which are cast on the seller, it's all very logical. Even if it was not there, every buyer would expect the seller to do so. Am I right? So this is how logically the legislation has gone for into each and every step forward while dealing with every aspect of law in Transfer of Property Act. Then again, after completion of sale, what is the seller bound to do? Even if there is no provision, everybody would say that he has to give possession of the property. He can't keep the possession. Then he has to say that whatever the seller's interest is in the property, that is still in force, and that he has a power to transfer. There is an additional duty which is provided when a person sells in a fiduciary capacity, saying that there is no encumbrance, or that he has not done anything which affects his right to transfer the property. Then he has to naturally deliver all the documents of title to the buyer, because if ultimately the buyer has to sell the property, then he should have all documents of title to show it to the prospective purchaser. Then, so once entire purchase money has been paid, the entire documents of title have to be handed over to the buyer. And that, as advocates, we would have a duty to our clients to ensure that all documents of title are with the buyer. Except, again, there is a condition that suppose somebody is owning 2 or more properties and the documents of title are similar, then the seller, subject to the agreement with the of the buyer, keep the documents and then provide certified copies, and with a covenant or with a provision that whenever the buyer wants, that original documents will be produced for verification by any other party or by the prospective purchaser. So certain, with certain exceptions, with certain precautions which are necessary to protect both the seller and the buyer, the legislature has always sought to create a balance and to protect both the interests. So this is how logically things have gone. Now, what is the rights of the buyer before completion and after completion? Again, very, very simple. If after the contract for sale or an agreement, if the buyer ultimately, after whatever time limit he has to look into the title and ask requisitions, if after that if he properly declines to accept delivery, provision is negative, it says unless buyer improperly declines, but we take it that if he declines it for some reason, then the buyer continues to have a charge on the property, like he would have some hold relating to the property, the interest of the purchaser on the property for whatever purchase money he has already paid to the seller. Naturally, if somebody has to be conveyed the property and to give delivery, but something is wrong on the property, naturally he would say, can you perfect that, you cure that, and only then I will take the delivery. Then he can't be kept in limbo, no? Okay, if you are not taking it, forget it now. Okay, I will enjoy your money, whatever you have paid. No, the buyer has a charge on that property for that whatever purchase money he has paid. Either he cures that defect and gives him delivery, or then if the sale has to be closed or cannot go further, then money has to be refunded. So he is entitled to for that charge on that purchase money plus whatever interest is payable on the purchase money. So to that extent, the buyer is protected. He is not just kept, as a step brotherly treatment aside, but he is allowed his interests to be protected. And everywhere it is who is honest, balancing wise. So only if he properly declines to accept delivery, that all these protections are given. Again, he is entitled to whatever earnest and costs awarded to him in suit for specific performance or for rescission. Rescission means for cancellation of the contract. So whoever is a honest person gets rewarded. And logically, without these people who may be normal people, very laymen who are selling the property, could also be aware. And logically, when we discuss with them, they also say that I have to be returned back my purchase money. There is a problem with interest. Without interest, that's their prerogative. But that is how a common man also thinks. And this is what Section 55 has tried to articulate. Without but it being there, also people would have gone on those bases only, majority of them. Then after completion, what is the buyer entitled? Definitely, you'll be entitled to all that what is rents and profits which accrue of the property. And secondly, if there is any improvement or increase in the value of the property in between the contract for sale or when there is an agreement between them and subsequently. So he is entitled to improvement or increase in the value of property. Similarly, vice versa. If there is any fall, he will be having to suffer. Again, so logical. If you want to take it, whatever happens, you can't be. Otherwise, there will be several disputes between the parties. Sometimes people say in development agreements and all those where there is ultimate conveyance to take place, if there is change in the policy and there is an increase in FSI, we would also want, I mean, all those part of it lead to disputes. Then there should also be vice versa provision that if there is a reduction in FSI, then the other party will also suffer. So everything beneficial, beneficial, beneficial we want to. Then what is the sanctity of contract? The sanctity of contract would be once you have agreed, whatever happens to that property is for the benefit of the buyer. And that is what the legislature has tried to do, to keep honesty, keep truth in the society. They expect that everybody would be honest and would go as per the terms and conditions of the contract. The letter and spirit will be honored and respected. That is what the legislature has thought about. Legislature believes that every countryman is honest and will fulfill his part of the contract. And that is how logically it has gone. We also, when we purchase any property, we also think that the seller will be honest and would perform as part of the contract. This is how the legislature also has proceeded. Now, again, rights and liabilities of a buyer. So when we talk about liabilities of a buyer, so he is bound to disclose to the seller, like the seller has to disclose to the buyer any material defect. He also has to point out that something, there is a increase in the value of the property, which the seller is not aware. Again, if he doesn't do that, it would be a fraud. Now, suppose today's newspaper provided that one of the farmers, he found a diamond in the property and which he sold for a very substantial amount. Suppose something like this, the buyer is aware and he doesn't disclose to the seller and therefore he purchases it. Section 55, the part liabilities of a buyer, in that it is a fraud, right? So anything which would be fair to both the parties. Now, buyer would get the interest, would write, but it can't be to the detriment of the seller. So therefore, if he is aware of something which will materially increase the value of the property, he is bound to disclose. That is what the legislature says. Then he has to pay or tender the entire purchase price. Logical. Before completing a sale, naturally the buyer has to pay the seller the entire price. And after completion of sale, what he happens, the vice versa. Like if he is entitled for increase, he is also entitled, liable to bear the loss arising from any destruction, injury, or loss. But again, very fair that such a loss should not be caused by the seller. Then he has to pay public charges and rents payable in respect of the property. That is, he has to do. But if he doesn't do it, that is to his detriment. That would be auctioned and it would be attached and it would be sold by public. So that is for his own protection. And if there is any encumbrance, and if that encumbrance is what the property is sold subject to, then whatever the interest and whatever the principal amount is due afterwards on that encumbrance, he is also entitled to that part of the remuneration. So once the sale is completed, it all comes to the benefit of the buyer. Now, this aspect that, rights, liabilities of a seller, rights, liabilities of a buyer, logically it moves forward. Similarly, there is a provision which is very, very logical. Don't go by the topic of it. Marshalling by subsequent purchaser. It looks very frightening. It's a marshalling. What does it mean? Some kind of a war, kind of a word. Marshalling by subsequent purchaser. So students get worried by the word itself, and they just don't want to read section 56. But I said that it is very simple. To my juniors, I explained. They said, "Sir, we never thought that it would be. We used to leave it for option question. Our teacher never explained to us, so we left it for option. Now you are explaining. It's very simple. So if you read it logically, you'll understand how much common sense it is, that if one person, if he is owning two or more properties, right, and he has mortgaged one of these properties to one person, and then he sells one of the properties to some third person. Now he can thereafter, or the law cannot be that whatever the value of the property is, even what is sold should thereafter, if in case of default, should be sold and the mortgagee should be paid. I mean, that would be so much unfair to the transferee. So what the law has tried to balance and protect the interests of everybody by saying that, okay, buyer, you have taken it, you were aware that it's a mortgage property, but you have taken it subject to mortgage, but no issue. If there are other properties which are also mortgage, then you have an option or you have a right to have that mortgage deed satisfied out of the property or properties not sold to you. So the mortgagee has three properties, suppose, and owner has sold one of the properties and there are two properties with the mortgagee, then buyer has a right to say that mortgagee, please sell the other two properties. Don't sell my properties. You sell those two properties and you satisfy your claim, your interest. That right he has been given. But it also cannot be unfair to the mortgagee, or to any other person who has any interest in the other properties for consideration. So it says that it should not, this right of the buyer should not prejudice the rights of the mortgagee. Again, very fair. If mortgagee's rights are protected by selling the other two properties, then he doesn't need to go after the buyer's property, the property which the buyer has bought. But if his rights are not protected, or if he doesn't get back his money, then he is entitled to go against the property which the buyer has purchased. Because as you are all aware, mortgage also has to be a registered document, by a registered document. So by ordinary prudence, the buyer would know that such a property has been mortgaged. Or even if title documents are original are not available, you would know that some party has either a mortgage or a charge. So very, very simple. If properties are enough, mortgagee can sell and do it. Buyer is happy, mortgagee is happy. Transferor also is happy because he has got money. So very logically, the legislation has gone forward and had tried to balance and be fair to all the parties concerned. So as simple as this is marshalling. Now encumbrances and the court sells it. Okay, either it is sold in execution of a decree, or the high court or the district court, as the case may be, or any other court which is the law provides. It sells an immovable property which has encumbrances. Then if there is any charge on the property for a monthly sum, or if there is a capital sum, then what the court does, that when it wants to free the encumbrance, so that whoever is the purchaser in auction, the auction purchaser, he should not be saddled with that encumbrance. So it's very, court has been given the duty to protect the auction purchaser to a large extent by allowing certain payments to be made in court, and then declare the property to be free from encumbrance and to order conveyance. Right now, not many judgments on Section 57, but there is a Kerala High Court judgment which says that when there is a notice to be given, it's not compulsory, but sometimes if the notice to the encumbrancer is given, even if the encumbrancer opposes, the court has complete power to override his objections and to direct this course of action, so that the auction purchaser who relies upon the court and comes to court for purchasing the property in an auction which takes place, or in a sale which takes place through court. So auction purchasers' rights are properly taken care for under this provision. Again, very fair, because ultimately the encumbrancer, whatever, whoever he is, whatever charge is, if he is satisfied, he can't then object and say that I won't permit this property to be freed from encumbrance. Whatever his entitlement is, that has to be taken care of, and that is taken care of. So thereafter, nobody can at his whims and fancies say, I will not allow the sale to take place without encumbrance. The court does not permit. The law doesn't permit. The law is protecting an honest person who deals with the property in an honest manner. Whatever his rights, whatever his claims, he claims it genuinely and in an honest manner. Doesn't try to create obstacles, or doesn't try to create any occasions which would be amounting to extortion. The law doesn't do that. It's only sometimes, many times, these things happen because of the delays that unfortunately take place in adjudication by the courts. Because of the time constraints which the court has, delay takes place with the kind of population we have, with some approaches which people have. The courts are saddled with many matters, and therefore, many a time, trespassers and encumbrances try to take advantage of the situation. The law doesn't permit that. The law protects it. The law only wants people to be diligent and to take action. And therefore, Limitation Act is provided. Many times, if it is in a fiduciary capacity, Limitation Act would not apply. But if you allow your property to be trespassed, and you, to your detriment, to people have a title made out, where they challenge your title, then if you sleep over your rights, naturally you will lose that right, because ultimately the legislation wants a certainty. It can't allow uncertainties to go on forever and over. So therefore, time limits are provided. So one has to be diligent in doing things for redressal of their rights. So this is how the legislation has gone. Encumbrances also, the court decides, and court says, sorry, now when the auction purchaser is there, I will, whatever protection the encumbrancer has to be taken place, I will protect him, and I will allow the sale to go through and the conveyance to take place as if there is no encumbrance. Now, sale, as I said, sale is when it takes place, when a price is paid between two living persons, which is there where parties have a consenting power as under the Contract Act, and it has to be by a registered instrument, and it has to be a non-testamentary instrument. Instrument is defined under Transfer of Property Act. I had explained last time. Now, what is exchange? Now, exchange is if suppose two persons are there, and they say that mutually we will transfer the ownership of what is in my ownership and what is in your ownership, I will transfer. Now, it may be two lands, or it may be one land, one movable property. Values also may differ. They may compensate it by whatever the balance by money or whatever it is. But ultimately, this is a sale. All the rights and liabilities of a seller becomes to the person, one person. He is both a seller as well as a buyer in an exchange. Both are sellers and buyers. So both are have the rights and both are bound by liabilities under section 55. Right? So all that becomes applicable as far as exchange is concerned. Now, it can be, as I said, once you give it owners of two people, you either exchange that one land at Goregaon is exchanged by a smaller land at say Kulaba of same value people think, then a document deed of exchange is entered into. It is really a sale, but instead of money, you give a property. And both things being money means you can exchange whatever manner. So exchange is in reality a sale, but here instead of a commodity or a property, immobile property and money, it is two properties. So otherwise everything is same. Otherwise everything same. It has to be by registered document. It has to be stamped. It has to have a consideration, and all rights and liabilities of a buyer and seller applies to both the parties as if they are both buyers and sellers. Now, again, very logical. Suppose there is an exchange taking place of a property and one of the property is defective, and therefore the one party gets say the land in Goregaon, but the Kulaba land there is a problem and therefore somebody doesn't get that. Then logically what would happen? Naturally, he has suffered a loss. The one who has to get the Kulaba property is in loss. So he has a right for redressal or for damages for the loss caused thereby. If there is any difficulty in getting the other property, and at the option, again very important, he has the option that if he now doesn't want to go forward with the deed of exchange, then he can demand and he has the right for the return of the thing that is transferred. But again, here the legislature has tried to protect the person who is a subsequent purchaser for value and in good faith. So if person has got the Goregaon property and he has sold it to somebody else for value, then the other person, the the other exchanger could lose his right to recover possession. Then he is only entitled for damages for the loss caused. Again, very logical, because if somebody has paid money and then why should he get entangled in the dispute? He may be joined in as a party. Somebody would want to proceed against him also to create, but his rights are protected. Ultimately, the courts will protect it. That's how the law is. If somebody just goes by the letter and spirit of the law, he would not proceed against that third party. He would say, you be happy, you have paid the money, you are not a gratuitous purchaser, you are not a gratuitous transferee, you have done everything what was required, and now I will not harass you. And therefore, I'll go against only the person who has cheated me for my loss, to recover my loss. And as I said, it's like a sale. So therefore, both the parties has the rights and are subject to liabilities of a buyer or a seller as to what he takes. So therefore, is a buyer to what he takes, and as a seller to what he gives. Very simple. You just look at it and you say, yes, of course. He gives a property, takes a property. So he's a seller for that property, is a buyer for this property. So he has to have rights both. Section 55 in toto applies to this people entirely. Right? So this is how it is. Now, if there is a exchange of money, so what is the guarantee which is provided? The guarantee which is provided is this money which I'm giving you is a genuine money. It's not a fake money. That's the only warranty which is provided if there is an exchange of money. Again, naturally, you can't have a counterfeit given and saying that oh, there is an exchange. You can't give for genuine money a counterfeit money and say that the transaction is closed. It is genuine. It's genuine, and money here not only is coins, currency notes also. The only thing is it should be genuine money. It should not be coming from our neighboring country by making to fool our people. So now whatever we have considered like sale and exchange, that's for a consideration. Now when we are going into where there is an absolute transfer taking place and certain transfers are conditional, which I will explain which conditional gifts are valid, which are void, as also that in what circumstances a party, that is the donee, has a election, has a right of election to make whether you want to accept the gift or not. I will explain to you. Again, every provision which goes about, every provision which is here, except say maybe 129, it's all proceeds on a very logical manner, very logical manner. So majority is all logic. Now you want to give a gift, you are entitled to give a gift. Natural love or affection, you provide a gift. The only protection with the legislation, because to avoid that, to maybe to avoid showing capital gains, or to if consideration amount which is received other than which is disclosed. So legislation in Income Tax Act has provided certain provisions, but that is a different aspect of law. But that is also very important for everybody who is going to be a budding lawyer to understand that there is provisions in the Income Tax Act, which earlier was gift tax. Certain provisions have now been put in under the Income Tax Act to protect certain underhand dealings and to show it as a gift. So when voluntarily a person wants to give a property and not take any consideration or take any money, and if that is accepted by or on behalf of the donee, then it's a gift. Now again, there is a provision which is that it has to be by a registered instrument. Naturally, since the property then passes on to the donee, everybody in the world should know, because the one who's the donor thereafter cannot go across and sell the property, and therefore to that it is protected. The other protection is that there should be minimum two witnesses. Normally attestation, the definition provides that there has to be two witnesses. The gift specifically makes it compulsory that minimum two witnesses are necessary. Again, very important provision, because for the gift, it has somebody has definitely given voluntarily without any coercion the gift. There are two people who would be then watching for it, that yes, he signed it and he was in complete sense and he was fully conscious and therefore he did it. So that's how the law has made it, that minimum two witnesses should be there. And if it is a mobile property, then it can be also by delivery, right? And when is the acceptance to be made? Naturally, this is a document which is by two living persons. So therefore, all the conditions have to be fulfilled during the lifetime of the people. So during the lifetime of the donor, and while he is capable of giving, that acceptance of the gift has to be made by the donee. And if the donee dies before acceptance, then the gift is void. So very clear that there has to be a giver and there has to be an acceptor, and both people should be living. Very simple, very logical. Now I just had to try to bring about certain elements of gift and go through, because earlier itself I have explained to that. But there has to be a donor and a donee. There has to be a subject matter of the gift, whether immovable or movable. Interest is created by the donor by his free consent and without consideration. And there has to be an acceptance during the lifetime of the donor and the donee. And this instrument has to be attested by at least two witnesses. That's the essential elements of the gift. Now, this again I have explained, when in an immovable property, how the gift is affected, and when there is a movable property, how it is affected. In a mobile property, it can be by a delivery also. There is no necessity for registered instrument, right? So there's a slight difference how immobile and a mobile property can be gifted relating to the effectiveness of it. Now, again, for certainty of uh, mercantile and for certainty of that whether the acceptance has to be when the both the donor and donee are alive, the legislature has tried to create a distinction and has been very logical in its thinking. It says it must be of an existing property. If there is a gift of a future property, that such a gift is void. And then the competence of the legislature and the thought process of the legislature is immediately highlighted over in the subsequent provision, which says that if it is both of an existing property and the future property, then only the latter part of it is void. So it doesn't say that the entire gift is void. So this is how fair and logical the legislature has thought. Saying that, okay, somebody has made a mistake by giving future property, we will not destroy the entire document. His intention was to give existing property also. So we'll keep that. as valid. That's how the legislature has gone across. Again, if it is to several people, right? Now, again, the legislature has been very logical, very fair, very understanding as to not brush aside the entire document, not destroy the entire document. What it has done is it says give to two or more donors, and if one doesn't accept it, then it is void only to the interest which the person who rejects it, only to that extent it would void. And that part of the interest then would continue to remain with the donor. So it doesn't, cancel the entire document. It creates a very distinct distinction between two parts. One who is not to be blamed, one who is accepted it, you take your interest, and it gives back to the donor and gives the right to the donor to do whatever it wants, to gift it to somebody else or sell it or keep it with himself. Now, again, very clear, and there is a Supreme Court recent judgment on this aspect. And you see, the beauty of our jurisprudence is that everything depends upon the facts of individual cases. Very few that you would have direct judgments coming relating to the aspects of the matter. It's always mixed, and it's commendable how our courts deal with such complicated issues and complicated questions. The provision is very simple that since gift is voluntary and entire right of the donor goes away, so it can't be that the donor on his whims and fancies can say, okay, tomorrow I'll gift, day after I'll say I'll get it back. Mercantile that cannot function that way. Economy cannot function. So what the legislature has done, that it says, okay, if there is a condition, but that doesn't depend on the will of the donor. It's a event which either would happen or not happen. Then such a gift can be suspended or be revoked if that event does not happen or if the condition happens. So it's like a conditional gift. But if it is on a mere will of the donor, saying that I will give it, and tomorrow if I want or if I feel that I should not have given, then I will take it back. Such a thing is void. The gift itself is void. Right? It can't be left to the mere will of the donor. So legislature, again, very common sense, it has looked into it and said that there has to be consistency. You can't give and whenever you want, take it back. And this issue had arisen now in 2019 in a judgment between Govindbhai Patel versus Mathurabai Patel. Patel Mathurabai. Here, what had happened is a person had given gift, and then the question which had arisen was whether it is an ancestral property or not. And court, considering all the aspects and looking at the previous judgments, it came to a conclusion that once a property is a self-acquired property, and if that is bequeathed to a third party or to a son, then in the hands of the legatee, that is the person to whom it is bequeathed, will also remain kind of a self-acquired property. It doesn't become an ancestral property, and he can dispose it of. And in this case, the Supreme Court, looking at the earlier cases, laid down the law. But in this case, the Supreme Court said ultimately the issue was not reason, and therefore the presumption is that it is a self-acquired property. But it had referred to earlier Supreme Court decisions where clearly Supreme Court there is a finding that once it's a self-acquired property and it is bequeathed, then it in the hands of the legatee or the person to whom it goes, it remains as a self-acquired property and he can dispose it of as he wants it. Now there was another decision which is very interesting. Like there was a gift deed, which is of the Supreme Court, is of 2001. There was a gift deed which provides for complete absolute transfer of the property. There was no conditions, but then on the same day there was an agreement entered into between the parties, and that contained conditions. And that was like section 10 becomes applicable, that certain conditions which is in favor of the transferor, he in the exceptions he is entitled to put in. So the Supreme Court said that even if the gift deed did not have any conditions, if there was an agreement entered into, that agreement has to be read into in the gift deed. And if that provides that if certain conditions on happening or not happening of certain conditions, the gift has to be revoked, then that is a valid gift. And the donor has the right to suspend or revoke the gift. That's how the Supreme Court has gone about. So therefore, it is not on the will. There was under that judgment, as I remember that in that judgment, it was that within 6 months, a medical college will be built. And there was a failure on that. So moment the donees, they expressed their inability to make the building, they tried to get back the property, and therefore the challenge went till the Supreme Court. So this is how, if it is not dependent on the will of the donor, then a gift can be revoked. Now, if that can be revoked with for the consideration for the you know any conditions which is put on, it can also be revoked if on any of the grounds a contract can be rescinded. Like if it was, say, not for by own volition, it was coerced or for the misrepresentation, then also it can be rescinded. But there cannot be rescindment taking place on the ground of no consideration, no contract, because the entire concept of gift is it is voluntary and without consideration. So that cannot be a ground for revoking or rescinding a gift. Now, again, very logical, Section 127, very, very logical, that sometimes a gift may not be of purely beneficial character. It may be, have some conditions which the donee may have to accept. Such a gift is called onerous gift, right? Now, if there is a single transfer taking place of several things to same person, and it's composite gift, if it's a composite gift, and if one of the properties is burdened by an obligation, then the donee has to accept everything. Otherwise, he gets nothing. See the beauty of the logic. If entire completing, he can't then pick and choose because it is a composite. You cannot divide it. So either you take it with the obligation or you don't get anything. So you take it or lose it, kind of. No in between in such a gift. But if there are separate or it is divisible, independent gift, and one is beneficial and others are onerous, then the donee has a right to accept the beneficial property and refuse the others, even if that others are onerous. He can only take the beneficial part. What can be distinguished, divided, legislation has given it the right to the donee. It doesn't want to completely deny the benefit, completely set aside the gift. So this kind of subtle distinctions, which are very logical if you think across, and if you think and you say, हाँ सही है, I mean, बराबर ऐसे ही one can do that. It is kind of as a matter of course. Anybody would do that. If he is given an election, power of election, then he has a right to elect. I will only take beneficial and not onerous. That the donor only has given him that benefit, not that election. Because if he does a complete composite, there is no election, so everything fails. But if he has given him a right of election, then he can take the beneficial part. Now again, very logical. Suppose the gift is given to a person who is not competent to contract, to a minor, and he even accepts it, but then he is not bound by that acceptance. If it's burdened by obligation, he is not bound. But suppose after he becomes competent to contract, and on being aware of that obligation, he still retains the property. Then again, logical, okay, be aware, now you are competent to contract and you still accept it. Then you are bound by it. Then you can't say, sorry, when it was given to me, I was not competent, I was very young. No, but now when you have become old enough, you have to take it. Now the same logic now arises where it is like a, I mean, what is a universal donee? Now, as I last time pointed out, that everything is logical, but to create importance for lawyers, legislation tries to put certain technical words or certain things over here, like marshalling. So it has put in a universal donee, so that people who are bound to come to lawyer to understand what is universal donee. But it's very logical thing. Universal donee means you are given by the donor whatever in the universe belongs to him. So everything. So you are a universal donor. So everything, whatever the donor has, he has given it to you. And once you are a universal donee, then what is your duty or liability? You have to take the entire gift and become liable for all debts that are due of the donor at the time of the gift. So when he gives you the entire property, he along with you gives you all the liabilities also. Logical, because he can't thereafter pay the liabilities. And he feels that you will make use of good of the property and you will pay off the liabilities. So he says, okay, take all my property, now take care of all my liabilities also. So you can't say, I will take your property and you bother about your liabilities. So you are said universal. He thinks you are an expert who will do everything possible to get the best out of that property, and you will pay off the all the liables. liabilities and all the debtors. So you do a very great thing for the community also. But to protect you, I mean, you may be one of the most brilliant guys, but ultimately it is destiny. And suppose you fail, then what the legislature has done is not put you into some kind of a big punishment, saying that, oh, you accepted, you tried to be brave, so now you have to pay all the liabilities. No, you are not to pay all the liabilities. Universal only has to pay liabilities to the extent of whatever is the value of the property which is comprised in the gift. He can't be put to tremendous punishment and said that you were foolish enough to take it, because the legislature wants that suppose somebody is not in a position to pay off his debts and he feels that there is somebody else who is brilliant enough to do it, then he should have the some kind of incentive. He can't be saddled with entire liability. So he is given an incentive to take it. Otherwise, what? You will lose only this, whatever is in the profit. But do your best to pay off the other debtors and you make money out of this. So this is how the legislature has been, very thoughtful in putting law on paper. Even if you see actionable claim, it sometimes it is possible that one person, even if he has a right to recover something, but he may not have the expertise or the wherewithal, the finances to do so. So courts, legislature says, okay, you cannot go to civil court for recovering that. You give it to somebody else who has the ability and the expertise to do so. But importantly, legislation has been thoughtful enough. So what it has done, it has put a very tremendous restriction to protect genuine people and people who are sufferers and who are not forced to. So what they have done, they have put a restriction as to who can enforce this right. If actionable claims are, you know, given, then some people are restrained. Some people can't get it. Now, who are those people? The people who are, say, legal practitioners, judges, and officers of court. They cannot purchase it, and there is a restriction on the courts also to enforce that right if they make an application to the court that we are transferees of actionable claims. So now you help us to recover this debt or this security. Look, there's a bar by the act itself. Now, those are very few bars which legislation had put on the court itself. One of it is in the Limitation Act, that if it is barred by limitation, then no court shall. So there's a, it's whether a party raises limitation or not, it is the court which is barred from hearing such a matter. Similarly, in an actionable claim, if it is a judge or a legal practitioner or an officer of the court who is the transferee of an actionable claim, then the court itself is barred by enforcing that right. So section 3 defines actionable claim to mean a claim which is a debt other than a debt secured by a mortgage of immovable property, because that then is provisions of section 58 to 104, which is relating to mortgage. So therefore, to that extent, that's not an actionable claim. Or by hypothecation or pledge of a movable property, again, that's not a debt which comes within the definition of actionable claim, and which may be existing, accruing, conditional, or contingent. Such a debt may be existing, accruing, conditional, or contingent, or any beneficial interest in the immovable property, whether in possession, actual, constructive of the claimant. That's not important. But what is important is that the civil court recognizes it as one of the grounds for giving relief to the claimant. This, while reading sounds to be a very complicated provision, but it's very simple provision. And what it does, it says intention is that somebody may not be in a position to enforce, this relief through a civil court. So it says you have a beneficial interest, there is a debt which is existing or whatever, you can transfer it. You transfer it to a third party for a consideration, right? And the court recognizes such a transfer. Now, there are only those conditions. Again, it has to be by execution of an instrument, which is a non-testamentary instrument. It has to be signed by the transferor. And as I pointed out, the transfer is complete upon execution. There is a provision in this for notice, but that notice, whether given or not, doesn't matter. Transfer is complete. That notice is for some other purpose. That is for subsection 2 of section 130. But transfer is completed. And whatever the rights of the transferor is, will vest in the transferee. But the transferee should not be a judge, legal practitioner, or officer connected with court of justice, right? And if apart from these three, whoever is the transferee, he can institute a suit in a civil court in his own name. Now, if there is no notice, may say why is there notice provided? If there is no notice, then if any person, the debtor, he deals with the debt, he pays off the transferor, suppose, or so has some understanding with the transferor. Then, if the debtor was not aware of this transaction, if you are not expressly brought about to his notice, then he is not bound by this transfer of actionable claim. So again, the legislature or the court has to favor person who is honest and person who is diligent. So if you are taking an actionable claim, then better give notice. Otherwise, if some debtor pays off the transferor, then you can't go against the debtor. Then it would be the transferor who has played a fraud on you or has cheated you. So therefore, better give notice. And there again, it is provided that it has to be in writing, signed, and in case refuses to sign, the transferee can also send it to the debtor. But to avoid any complications, any multiplicity of proceedings, better that a notice is provided. Now, again, very logical that if you are taking an actionable claim, like in the property, you are taking it to all liabilities and equities which the transferor was subject to. So you are aware, bound to be aware of everything, and you can't say that, oh, I will only get this and I won't get that. Everything is composite. You can't create a division. If you take it for benefit, you are also bound by the liability. Again, very important aspect, and again, consistency and for mercantile business. So when an actionable claim is transferred, there is a deemed warranty given by the transferor that the person against whom there is a claim, the debtor is solvent. Again, to create that consistency and to protect and avoid all sorts of dispute, it is also stated that the warranty is only on the date of the transfer taking place. It can't be uncertain for all times to come. Tomorrow, if after the transfer, tomorrow he becomes insolvent, then that is not the transferor. He is only till the date of the transfer. And suppose something is wrong, then it is limited to the amount of value of such consideration. It can't be anything. So there has to be, when you are purchasing it, you're purchasing it with full knowledge, but for some reason there is a problem, you get back whatever consideration you have paid if he was insolvent at the time when the transfer has taken place. So there has been very consistent and a very logical and a fair manner in which the legislation has proceeded. Now again, when you take it about this, mortgage debts or any debts, what it says that if you transferee receives any money, then first it has to be adjusted towards payment of costs of such recovery. Naturally, there would be costs, advocates' fees and all have to be paid. So that is the cost. So first it will be adjusted in payment of costs of such recovery. Second, towards satisfaction of the amount for the time being secured by the transfer. If a transfer takes place and it is secured by mortgage, then to that extent, it would be for satisfaction of the amount. And if there is any residue, if there is any residue remaining, logically, naturally, only then it will go to the transferor or any other person who is entitled to receive the same. So first, whatever is received has to go for, there is a priority laid down. And that priority also is extremely logical in its concept. Now, the next part of it is where there is a policy insurance against fire, and if that policy is assigned. So legislation provides that if there is a assignee by endorsement of a policy of insurance, and in that person also the subject which is insured, that is any immobile property or any other movable property which is insured by that fire, then what happens is whatever is transferred is completely vested in the transferee, and that vesting is as if the contract of fire policy has been made with the transferee himself. To avoid any confusion or to avoid any difficulties in future, the legislature has accepted or deemed to have, that person who gets is a transferee and he gets this fire policy with the subject property, then proceed on the basis as if that contract of is made by the transferee himself, by the insurance company. So there is no ambiguity kept. So if there is any difficulty, if there is a fire and that fire causes a damage or destroys the property, then transferee can proceed as if the fire policy is with him. So insurance policy company cannot create any difficulty by raising any such defenses. This kind of a provision is put to avoid any complications in future and to help mercantile proceed in a good and a consistent manner. Now, naturally, there is a saving because there is a Negotiable Instruments Act, which is a special law on the subject. So the legislature, in its wisdom, has thought that these provisions, which is transfer of actionable claim, would not apply as far as any transfer of stock, shares, or debentures, or to instruments which are of time being by law or custom negotiable, or to any mercantile document of title to goods. So those are all governed by, which are negotiable instruments, are governed by the Negotiable Instruments Act. So there is a special law on that subject. So therefore, actionable claim part of it is not applicable. There are special provisions, and that provisions will apply. So again, to avoid any confusion or difficulties, a kind of clarification is provided over here. That if there is anything which is relating to negotiable or mercantile document where there are other customs or anything, don't look at sections 130 onwards, 130 to 136, and it doesn't form part of definition of actionable claim under section 3. So those are not the provisions to be looked at. Those are other provisions which need to be looked at. So there have been absolute clarity and clear direction and purpose provided to everybody who wants to proceed in any manner. Now, this is as far as sale, gift, exchange, actionable claim is concerned. Now, Sunita was telling me, she said, Ravi, you are proceeding and I want you to properly explain. Otherwise, I'll keep on saying once more, once more, once more. So I said, but I'm not singing. So she said, no, till you perfect yourself properly, I'll keep on saying once more, once more, once more. So whether you sing or whether you give lecture, I will always keep on saying once more so that you are perfect. So she said, okay, I will give you one more chance. That is on 11. Practice makes a man perfect. So more you speak, the more you are practicing and more you will become perfect. So I'm first time, second time you will be much better, third time you will be very good. And she said, I would want you to have till you perfect you fourth time, but then that is I will be thrown out of my job. So you better be perfect at the third time. So I said, fine, I'll try. I do not want you to lose your job because I know how diligent and hardworking you are, and every time you just keep on thinking about find me a like speaker, find me a speaker, and find me a subject, and how tactfully and beautifully you find subjects. So I said, no, plea requires you, and all these people, young students and young advocates also require you a lot. So I will keep on practicing and doing well. I will only take one more third time. Third time I'll be perfect. Sorry, Sudhita, if I do not get perfect on the third time, but I'll do everything to be perfect. So now I have covered sale, exchange, gift, where there is absolute transfer, as I have pointed out. There would be onerous, there would be some conditions, but ultimately it is the absolute transfer taking place. There are two transfers, that is mortgage and lease, which is entire rights of the uh, transferor doesn't get transferred, and he has a right in a mortgage to redeem the property before it is forfeit. There is a foreclosure, and in a lease is entitled to the benefit until there is a foreclosure or the period comes to an end. So now what I'll do is I'll just define lease and I'll define immobile mortgage. Mortgage, there are 6 kinds of mortgages. I'll define that and then try to be good in my explanation on the 11th. So lease, as I tried to break it up, it is immobile property is a transfer of a right to enjoy such property, entire right. That is again a right in rem. As far as if it's a license, it is a license in persona. Here it is a right in rem for a certain time period. Now the time period, it can be in perpetuity also, but an entire sale doesn't take place. It's only a right to enjoy such property, and there is a consideration for a price paid and to be rendered periodically. That is on monthly basis, 6 monthly basis, yearly basis. depends upon the understanding between the parties. And when such a transfer takes place, the transferor is a lessor and the transferee is a lessee. And whatever the price he pays, that's a premium. And periodically, whatever he pays, any money or any other thing, that is a rent. So now these is a very detailed provisions, rights, liabilities, forfeiture, many of the aspects which I would try to cover on the next location. Now it is a mortgage. Mortgage again is the transfer of an interest in specific movable property for the purpose of securing the payment of money advance or to be advanced by way of loan, and could be an existing future debt or performance of an engagement which may give rise to pecuniary liability. This is again has to be registered, and depending upon which kind of mortgage the mortgager wants it or a mortgagee wants it, the document would be prepared in that fashion. And transferor is a mortgager and transferee is a mortgagee. Now I'll just tell you in passing that there are 6 kind of mortgages, which is a simple mortgage, a mortgage by conditional sale, a usufructuary mortgage, an English mortgage, and mortgage by deposit of title deeds. And the residue of that, if they are not any of the other 5, then that is a anomalous mortgage. Now I take it that on 11th, most of you would be there and you will tell your friends also, because I will try to cover in as much detail as possible the entire gambit of mortgage and lease. Thank you.
Thank you.
Thank you.